Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and this video is part of our series entitled Overconfident Sellers plus Overeager Buyers equals Broker Liability. And we are going to focus today on one aspect of sellers prohibiting buyers from conducting inspections. We will have another segment on a similar related topic regarding inspections, but slightly different. So the discussion today involves the risk associated with listing brokers giving advice to sellers that it's either okay or even a good practice to prohibit buyers from conducting inspections. And we are going to make this discussion broad enough that it includes not only the prohibition of buyer inspections, but also the elimination of the information verification language it's one of the last paragraphs in the boilerplate purchase and sale agreement. Many listing brokers are requiring that buyer offers include the elimination of the information verification provision language. Real quickly, the information verification language simply says that the buyer has the right for the first 10 days following mutual acceptance to terminate the agreement if buyer discovers a material inaccuracy in any representation sellers made. So it's not a get out of jail free card like the inspection contingency is. Buyer has to be able to identify a material inaccuracy in one of seller's representations. And sellers are requiring the elimination of that paragraph in many cases, and then requiring that buyers make their offer with no inspection contingency. And of course, if buyer doesn't have an inspection contingency, then buyer has no right to inspect seller's property at all. All right, keep all of that in the back of your mind for a minute, because that's the risky practice. I want you to understand why that's a risky practice, because you might be thinking, maybe this is helpful to seller because seller avoids the risk that buyer will terminate the agreement based on the inspection contingency or ask seller to make a bunch of costly repairs, or even just the risk that the buyer will do the inspection, reveal defects to the seller that then seller will then have to reveal later to another buyer if this buyer doesn't close the transaction. All of those are thoughts that are reasonably based in your thought process of protecting the seller. But all of those thoughts are superficial in the real analysis of protecting seller's liability. Here's why I say that. We are seeing a trend in Washington law with respect to post-closing liability that says that sellers are going to be less and less liable for defective conditions in real property if buyers failed to conduct their due diligence. The best example we have of this is a case that was decided in the spring of 2013 by the Washington State Court of Appeals, and the title of the case is Douglas versus Visser. It's a case that came out of Bellingham, and in Douglas versus Visser, the Court of Appeals actually found that the seller intentionally concealed defects. There's no question as to whether or not that happened, no argument. The court found that the seller intentionally concealed defects within the home. And the defects were not insignificant or minor defects. To the contrary, the defects were so significant, it was rot, that was the problem. The only solution, because the rot was so pervasive, was to tear the house down and rebuild it. With those as the facts, what do you think the court decided as to liability? Was the seller liable or was the buyer liable? Seller intentionally concealed rot so pervasive that the house had to be torn down in order to repair the rot. The court found in favor of the seller. The court found in favor of the seller, and that the buyer had no claim against the seller, notwithstanding the seller's intentional concealment of the rot. Why? Because the court held that the buyer failed to conduct the buyer's required due diligence. In other words, the seller was protected from post-closing liability because the buyer failed to do the due diligence that not only did the court think the buyer should do, but it was due diligence that was available to the buyer. the buyer had conducted an inspection and failed to ask follow-up questions of either the seller or the inspector. The buyer had the seller's disclosure statement and failed to ask necessary follow-up questions with respect to peculiar issues within the seller's disclosure statement. Because that due diligence was available and ignored by the buyer, the court said, seller, you avoid liability in this case. I'm talking to you listing brokers with respect to the notion of whether or not it's a good idea for sellers to A, prohibit inspection contingencies, or B, cross out the information verification language. And I hope that with this example as a background, you're understanding that the risk in preventing a buyer from conducting an inspection or from preventing the buyer from having an opportunity and invitation to test seller's representations in the first 10 days of the purchase and sale agreement, that by eliminating those options from buyer's range of possible due diligence, that you are taking away from the seller a defense to post-closing liability. Now, most sellers are not like the seller in Douglas versus Visser who intentionally conceals damage. Most sellers don't try to take advantage of a buyer, don't try to commit fraud. Most sellers try to do the right thing, but somehow or another buyers still end up suing sellers after closing all the time because buyers' level of what they thought sellers should have revealed versus sellers' level of revelation with respect to defects, they aren't at the same, they don't meet each other somewhere. And as a result of that, even though the seller's not trying to be a bad guy, the buyer still has a claim against them. Those sellers, the sellers you represent every single day, have a protection in Washington law if the buyer has an opportunity to conduct due diligence and fails to conduct due diligence. But if your seller eliminates from the buyer all ability to conduct due diligence, buyer, you can't bring an inspector through our home. You don't have an inspection contingency. I'm not even giving you an opportunity to challenge the representations I've made. You simply must accept my representations on face value. You get what you get. Then listing brokers, you are setting your sellers up for a post-closing lawsuit that they cannot defend on what is emerging as the best seller defense in the Washington judicial system. Your boilerplate language is intended to create a transaction in the real world that matches the judicial and the legal expectations of Washington law. When you cross out the information verification provision, when you prohibit buyers from having inspection contingencies, you are actually putting your sellers in a risky position with respect to this issue. And I cannot caution you against that approach heavily enough. So, listing brokers, when your seller says, I don't want the buyer to have an inspection contingency, or I want to cross off the information verification provision, explain to your seller the risk in taking that action. Show them this video if you have to. But help them to understand that just crossing off the language or prohibiting the inspection contingency does not necessarily make long-term sense. It might feel really good in the short term, but long-term it could be a very dangerous practice. And if they insist on doing that anyway, if they insist on forcing the buyer to waive the inspection contingency or cross off the information verification provision, then you document your file. You put in an email. Seller, as we discussed, that means that you had an oral conversation about it and now you're putting it in writing. I believe it's a very risky practice for you to prohibit the buyer from conducting an inspection or crossing off the information verification language. I advise you to seek the advice of legal counsel before you counteroffer the buyer in that way. You've protected yourself by giving the warning and by giving the advice to seek legal counsel. This is really one of the most dangerous trends I'm seeing develop in the industry. Please think carefully before your seller prohibits buyers from inspecting the property, and please advise them to seek legal counsel if they want to do that. If you have questions on this or any other topic, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.